afternoon, everybody. I suppose all of you can hear me. You're all logged in from different places, and it's a pleasure to speak to you all on this subject of ITA 2008. I also thank Captain Mohandas and the CII team for enabling this webinar. As I go along, in case you have any questions, please keep it ready so that at the end of the main talk session, I would like to have as many questions as possible from all of you. Okay, we'll proceed now. During this presentation, we will basically first look at the relevance of ITA 2008 to a corporate executive, the essence of this particular legislation, which we are referring to as ITA 2008, and in particular, what are the due diligence responsibilities of CXPOs and corporate employees as envisaged in this particular legislation. Now, talking of the relevance of ITA 2008, for the purpose of clarification, let us understand that ITA 2008 actually stands for Information Technology Act 2000 as amended by Information Technology Amendment Act of 2008. ITA 2000, as most of you are aware, became effective on October 17, 2000. And it has been nearly 10 years since this legislation has been in place, which actually made a significant change to the Indian corporate scenario because it brought for the first time in India legal recognition to the electronic documents. The electronic documents are being used by corporates even before perhaps October 17, 2000, but at that time there was no legal validity for electronic documents, and in case anybody goes to a court, the email or a web page would not perhaps be considered as valid evidence. Despite that, India already had in fact even internet banking at this particular point of time, and it was only apt that the legislation was brought in to legally recognize not only electronic documents but also something called digital signature, which could be used on an electronic document to have a signed document in electronic form, which was as good as any other paper based document for contract purposes. And in fact, ITA 2000 was mainly enacted for the purpose of what we recognize as e-commerce promotion, to help more and more businesses make use of internet and electronic documents in their official work. Now, these amendments of 2008 actually was passed in the fag end of the year 2008 by our parliament, and they were notified for effectiveness on 27th October 2009, which means that we are just in the second financial year in the corporate circles where this particular act has become effective. This is very important because this ITA 2008 has cast several responsibilities on the corporate world, and some of these responsibilities are to be demonstrated in the annual report of the particular company. That is why I am saying this is the second financial year after the enactment of this particular act. In between end of March 2010, there was the first financial year when most of the corporates had not yet recognized the full impact of ITA 2008, and perhaps their annual reports do not fully perhaps display compliance of Information Technology Act 2008 version. Now, I hope during this year there will be more developments in the Indian corporate sector to ensure that we as a collective entity come out as a compliant industry, so that there will be better awareness, better compliance, and therefore better information security in the market. Why I am mentioning information security is that just as ITA 2000 was enacted with an objective of e-commerce promotion, This ITA 2008 focuses much more on information security, and it is in this connection that the companies have a lot of things to do. And ITA 2008 will, I hope, be considered as a key input to the corporate governance throughout this particular decade and later. And companies will sooner or later realize that neglecting ITA 2008 compliance will be an invitation to disaster, which can either cause loss, financial loss to the company, or even in the select cases, perhaps criminal liabilities cast on corporate employees who may be not having any malicious intentions, but may be negligent in imposing, following whatever prescriptions of Information Technology Act is there. In fact, to understand the kind of liabilities which one may get for non-compliance of Information Technology Act, we need to remember a couple of incidents. Most of us are familiar with the Bozzy.com issue, which was about 5-6 years back, when the CEO of this Indian arm of eBay.in faced and perhaps continues to face the prospect of conviction, which on paper at least has a 5-year imprisonment possibility. And this situation has arisen because there is a question on whether Bozzy.com had complied with what was the due diligence requirements envisaged under Information Technology Act 2000 version. Compared to 2000 version, 2008 version has got lot more responsibilities. Therefore, there could be lot more Bozzy.coms after ITA 2008 than earlier. Now, one more set of recent developments which corporates, particularly the banking segment, has to recognize is that in the last about 4 or 5 months since April, there have been at least 3 judicial decisions or quasi-judicial decisions, all going against banks in respect of phishing complaints. The phishing victim, who is a customer of the bank, was able to successfully fight and get a verdict in their favor and against the bank for the bank to take up the liability of phishing. One was the case of Uma Shankar versus ICICI Bank, where the adjudicator of Tamil Nadu granted a compensation of 12.85 lakhs to the victim for a loss of around 6.5 lakhs. Then in Bombay, the consumer court actually gave a verdict in the Nikhil Futon case versus HDFC Bank, another 3.5 lakhs liability the bank had to bear. And one more incident in Bangalore, in which the banking ombudsman actually took a decision in favor of the customer and directed Bank of India to make payment of the loss on account of phishing to one of the customers. In all these cases, one of the reasons why the corporate, which is the bank, lost the case was that they were held perhaps negligent in following the prescriptions of Information Technology Act. The cases of IT companies or other companies losing data is quite common. There have been BPOs who have found that their employees have sometimes stolen data. A couple of months back, there were a couple of medical transcription companies who found that some of their employees offered to sell data to a person in UK who actually happened to be a sting operator from a publication which caused a lot of flutter in the BPO market, to the extent that internationally people sometimes say that information security in India is not as good as it should be. We also must remember that there have been cases of hijacking of websites where we consider website as our the face of the company in the internet. If the face of the company is hijacked, then obviously there are issues of reputation and as well as other operational issues. In fact, even CII itself had once had this problem when its domain name was hijacked by a different person. And again last year, Bank of India had an issue where its home page had been hacked by a particular person, and several Trojans were placed on the home page in such a manner that whoever visits Bank of India website, the Trojans would try to download into their computer. And some of these Trojans included what we call as keylogger Trojans, which had the capability of stealing the password of the particular visitor from their respective computers and could lead to further losses. Now this indicated a sort of a necessity for the organizations who maintain web presence to ensure that the web pages or the files which appear on the website are secured as much as the electronic documents within their corporate network. In certain cases, we have also seen that domain names of companies have been booked by other people. It has happened for Canara Bank. It has happened for a company in several companies. One such company is EK Services in Chennai and KG Hospital in Coimbatore. So there are number of such instances where corporate entities who normally take so much of care about their assets forgot to ensure adequate security to their asset called domain name, and in turn faced a lot of embarrassment in the conduct of their operations. Just to add some statistics to what is very evident, that cyber crimes are on the increase, and everywhere people are using computers. Therefore, obviously the incidence of cyber crime on day-to-day life, including corporate life, is definitely something worth taking note of. And to reduce this into some available statistics, a recent study which was done in US tried to estimate what is the kind of dollar loss to a particular company on account of various acts of cyber crimes, which could be web attacks, malicious code which is virus, or sometimes insiders problems. And it has found that the average loss per company per year is around in rupee terms 17 crores, which means that there is a substantial potential loss for any corporate which has an existence on the cyber world. In fact, the study also reveals that there is almost one successful attack every week on a company. So the fact that there is existence of risk is something which need not be re-emphasized. And the attacks can come in various forms. It can be affecting the bank accounts. It can be in the form of keylogger Trojans, or perhaps stealing of confidential information. And we in the corporate sector need to ensure that our assets are always protected. When we say our assets, it is not only our computers, our buildings, it is the information residing inside the computer, which is an asset which is perhaps today in many companies worth much more than the physical assets. Now, having recognized that all this is there in the marketplace, the question obviously is how do we respond to the growing challenges? Obviously, the solution doesn't lie in walking away from the cyberspace, because cyberspace has got so many advantages, and today no business can survive without properly harnessing the benefits of internet, benefits of email, benefits of exchanging of electronic documents. In fact, what we are having today as a webinar is also an indication of how we can advantageously use internet. So we do need to adapt to this digital world and ensure that the risks are identified and properly mitigated. This is therefore a corporate governance issue, that since we have decided to work in this environment of cyberspace, we in the corporate sector need to have necessary solutions to meet whatever risks arise from that decision. In this context, if you want to reduce our say focus to one single word, it is called due diligence. That is, every company, every executive, every IT user need to know that he is expected to follow something called due diligence, which is today a mandatory requirement of our Indian law, which is Information Technology Act 2008. What we generally mean by due diligence is that it represents certain precautions to be taken by an organization or by a person so that the assets which he controls are not used for commission of any contravention of Information Technology Act. In a way, it is actually opposite of what we call as negligence. And just to understand what are the implications of not following due diligence, it is necessary for us to take a brief look at one of the sections of Information Technology Act called section 85, which talks about offences by companies. See, Information Technology Act has got several sections of various cyber crimes and other requirements, and if any of these cyber crimes can be attributed to a corporate computer, then we can say that the offense has been committed by a company. So we are looking at any offense which originates from an IP address which can be sourced or tracked to a corporate asset. Maybe it is being used by one of the employees of the companies, or somebody else might have hacked into the corporate network and used that network for whatever he wants to do. Like, as we have seen in some cases, terrorists have logged in a wireless network to another organization and sent out mails for furthering their terrorist activities, and when the police check or track such an activity, it obviously leads to the company's IP address, and that becomes the prime accused. When such incidents happen, what section 85 says is that every person in the company who at the time the contravention was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company itself, that is both the person as well as the company, shall be guilty of the contravention and shall be proceeded against and punished accordingly. This establishes that there is a vicarious liability for any corporate executive for offences which he himself does not commit, but it is committed by the network and he happens to be in charge of the conduct of the business. This does not apply only to the network administrator or the IT manager. Actually, it applies to any executive of the company who is in charge of the business, and obviously it includes the CEO or the top management. Of course, the section has an escape clause, and that escape clause is what we need to take note. It says that nothing contained in the subsection shall render the person for punishment if 1. He proves that the contravention took place without his knowledge, and 2. that he had exercised all due diligence to prevent such contravention. That is why we say that due diligence is very important, because if you have exercised due diligence, then even if you are otherwise liable under section 85, you can be protected because of the fact that you have exercised due diligence. This is the effect of section 85. It must be also recognized that if the contravention has taken place with the consent of or connivance of or is attributable to any neglect on the part of any director, manager, secretary or any other officer of the company, then such officer shall also be liable under this particular section. Again, he also can say that he was not aware of the particular contravention, but that is not sufficient. He has to also uh, perhaps demonstrate that he had exercised due diligence. It is for this reason that we say that every corporate should enable itself for not only exercising due diligence but also document it in such a manner that when a certain accusation appears under section 85, they can provide necessary evidence and then perhaps prove that they can be or they should be protected under section 85 because they have followed due diligence. Now, we will see how this due diligence manifests in corporate life. Normally, we say due diligence, but let us see how it actually manifests in the corporate life. Now, obviously, we are looking at the information security people providing us the necessary security in such a manner that this particular due diligence is followed. But we need to recognize that in today's context, when we talk of information security, we cannot stop at something which protects the data. See, in companies, many times we try to look at data security as a synonym for information security, but there is something which we need to look at in the okay. I okay. I suppose the audio issue has been sorted out. Okay. Now, when we talk of security, let us not stop at what we call as securing the data, in the sense that we are not considering it as complete security when we prevent, let us say, unauthorized access to data, unauthorized alteration or modification of data, which is actually something which most of us, say a couple of years back, considered as the end objective of information security. Today, what we feel is that security is no security if it cannot protect the information owner, in addition to, of course, the data, because whenever a security firewall is breached, it is not only the information which gets damaged, which has to be of course protected, but the information owner who is sitting behind the information, he suffers a loss. That is why we say the focus of information security is not just to restore, let us say, the damaged information, but to ensure that the information security owner does not incur any loss on account of an information security breach. It is here that we need to look at different types of securities. For example, at the first level, we say we take what is sometimes I refer to as technical security, which is ensuring that the data or the information residing in a computer resource is not accessed by any unauthorized person, and in the event, of course, it is damaged, then it is restored from our backups or the DRP uh, plans, and therefore technical security enables one, to the extent possible, prevent any unauthorized access to information, and in the unlikely event of unauthorized access which results in damage to the information, ensuring that the damaged information is restored. This is technical security. But what I am saying today is that this is not sufficient for our requirement. Now we have to go to the second layer of security, which is the legal security. And what we mean by legal security is that in the event the first layer of security fails, and therefore a security breach has happened, apart from recovering the data within the short time possible from our, as per our DRP preparedness, if during the period of that say security lapse, if the owner of the organization has come to suffer any legal liability, then we need to get it protected too. I will give the example. We saw some time back an example of Bank of India, the website being hacked. viruses getting downloaded to a visitor. Now, okay, after 24 hours, we restore the whole process. That is what the technical security does. The site comes back to normal state. The viruses are removed, so people can log into Bank of India website without any risk. Fine. But during the 24 hours or whatever time it took for the security breach to be restored, there would have been several people who would have visited the website. Maybe few of them got some viruses downloaded into their website, into their computers, and maybe they had suffered a loss. These people will come back after a few days or a few weeks or a couple of months, alleging that the bank was negligent in having their information security, and therefore they suffered a loss, and the loss should be borne by the bank. This is what we call as liability arising out of a security breach, even if the security breach is perhaps restored or corrected within a very short time. And this, at that time, now can Bank of India say that I had carried out all due diligence requirements and therefore I don't have to meet any liability? That actually tells us whether the security was adequate or not. That is why we say there should be legal security, which is the second layer of security over and above the technical security, and together we call that as techno-legal security. And another aspect of legal security is that in the event any loss occurs to the organization, if it is properly covered under legal security, then maybe the company itself will have a legal right to actually file a claim on whoever caused the loss and recover the damages. Here I can again go back to one of the earlier examples. We had an instance in Chennai itself some time back where an employee of a BPO copied some software from one organization and actually went and joined another organization where this stolen data was used. Now in that scenario, apart from this employee becoming liable for whatever cyber crimes he has committed, there was an issue that this second company which made use of this particular person's stolen data itself had a certain liability. Therefore, this company from which this person stole the data had a recourse to recover its losses not only from this person who committed the offense, which is that employee, but also the company which benefited from this particular say cyber crime. This would happen if they had followed whatever due diligence was required and the cyber crime had occurred despite their due diligence, and that would have given them an alternate source for recovery of the losses. And this should be the objective of all companies today, so that in the coming days, if we have got a proper techno-legal security, then we can see if we can get insurance for our data losses. And that is what I call as insurance security. That is, the objective of today's companies should be to move towards getting the corporate information assets covered by an insurance, not only against fire, water or rain or something like that, which every one of us does, but against cyber crimes. In fact, this data insurance against data theft or insurance against cyber crimes or cyber crime insurance or whatever way we call it will become an essential feature of the corporate entities' work in the coming days. In fact, I am aware that some of the US companies which are providing the BPO work to India have already started inserting a clause in their service level agreements that the Indian counterpart should take adequate insurance against data losses. This is particularly relevant in the space of where HIPAA stake is there, that is a health information from US is passed on to India for processing either by medical transcription companies or by other companies. And in US, because HIPAA is one such legislation where the data loss normally results in substantial damages, they always transfer this by indemnity to the Indian companies, and nowadays they have also started inserting a clause that the local company, that is Indian company, must have an insurance against such data thefts. In the sense that if any of our employees commit data theft and it results in say 1 million US dollars liability, I should have some kind of an insurance to cover this. I'm not sure whether the normal fraud insurance can cover all the requirement of today's IT world, because maybe some fraud insurance policies cover such cases where the employee of an organization commits a financial fraud. But when we talk of an external person who hacks into a corporate network and commits a fraud, it's actually a third party cyber crime, and definitely insurance companies would try to avoid any liability, holding that the company itself was having perhaps a weak security or something like that. It is in this context that ensuring techno-legal cybersecurity of an adequate proportion and documenting that through an appropriate audit and certification becomes an essential part of today's corporate governance. And this transition is reflected in the transition of information security objective from the current DRP BCP approach, that is disaster recovery plan and business continuity plan approach, to what I call as defensive legal protection and offensive legal remedy approach. That is, the security should enable that we will be able to defend legally against any external person making a claim on us, that is DLP, and it should also provide us the legal power to actually file a case against an outsider to recover our losses. This is offensive legal remedy. So this is what I would like all information security people to start looking at. That is, they have to consider this DLP OLR approach as a step ahead of DRP BCP plan and ensure that all their security practices are augmented with legal security, so that you will soon be covering your company not only from any loss of data but also any legal liabilities arising out of that particular loss of data. This concept is not only a sort of a best practice which we would like most companies to follow, but as of today, Information Technology Act 2008 makes it a legal mandate. That is the difference between 98 2000 and 2008. Today, security is something which is not, there is no alternative. For example, whenever a listed company today submits its annual report, they provide this clause 49 of the listing requirement one certificate, and this certificate, which is signed by the CEO and the CFO, states that the statements made in the annual report present a true and fair view of the company's affairs and are in compliance with all existing accounting standards as well as applicable laws and regulations. Today what happens, most of the time the companies only look at accounting standards, forget that this clause 49 also covers applicable laws. And if a company is not compliant with the applicable law, they actually have some liability arising out of non-compliance, and that liability in financial terms affects even the company's statements of say financial position. For example, recently one large company found that there was an insider fraud, because of which they had lost 20 crores of rupees over a period of 3 years. Now if one analyzed the modus operandi of this particular fraud, it appeared that it was possible because there was some kind of a slackness in the information security practices of the company. Now if such slackness could lead to 20 crores liability, obviously it affects the financial statements of the company, and therefore the company's declarations stating that they had no liabilities was actually an incorrect statement in the earlier years. Similarly, now the recent judicial decisions against the banks in phishing mean that if any bank is not following law and therefore it is liable under the phishing possibilities, actually their financial statements need to be qualified to say that the company is not fully covered against phishing, because maybe one of the reasons is the bank is not using digital signatures for sending their emails, which was one of the reasons stated by a judicial authority in the Uma Shankar's case, and also because most banks are not using digital signatures for internet banking. Because of that violation, they may have to qualify their statement saying that we are not following Information Technology Act fully, and therefore there are likely some liabilities on the bank which have not been adequately covered. And when such qualifications are there, obviously it also affects the financial statements, the Basel II declarations, and even the directors, independent directors, the chairman, they all become liable for any adverse consequences coming subsequently. That is why we say that there is a legal mandate today that the company takes all steps for compliance. Now, such a step towards compliance obviously starts with a risk analysis. Now, there are many companies who have done an ISO 27001 audit or BS 7799 audit or whatever kind of security audits they have done in the past. However, they should also do an audit with a specific focus on Information Technology Act, because this is something which is slightly different from the security audits. Just as when we conduct say HIPAA audit, we do it even when a company has already done an ISO 27001 audit. As of today in India, every company needs to undergo an ITA 2008 audit, which identifies what are the risks which the particular company is facing in the light of provisions of Information Technology Act. This is what is evident in Information Technology Act, which has converted security from a technical issue into a legal issue. For example, cyber security today is no longer a mere definition of say quality or technical requirement. In fact, section 2 NB, subsection NB of Information Technology Act 2008 actually provides a legal definition for cyber security. Of course, this definition is what even security people, technical security people have been following earlier also, but it is necessary for us to recognize that today if anybody asks what is cyber security, we must say that there is a legal definition available in Information Technology Act, and it says it means protecting information, equipment, devices, computer resource, communication device, that is the mobiles or routers, and information stored within these devices from unauthorized access, unauthorized use, unauthorized disclosure, disruption, modification or destruction. So today we have to look for the legal definition of information security and look at how we approach this particular issue. ITA 2008 actually defines certain norms for security in one clause where it refers to it as reasonable security practices. Secondly, it defines punishments for non-compliance, and it pushes for a continuous improvement of standards through the concept of due diligence. To support all this, it has set up an official infrastructure for managing information security, starting with the CERT-in. Now, if anybody looks at a corporate entity under ITA 2008, the risk assessment steps go through several aspects, starting from section 65 to 74 and 85, which talks of criminal penalty risk, there is civil penalty risk, there is contract risk, e-audit risk, authentication risk, information demand risk, data retention risk, and data privacy risk. There are many companies who have recognized only one aspect of it, something like data privacy risk, and perhaps the rest of it they are ignoring, and it is time for us to look at how we meet all these requirements. When we talk of reasonable security practices, the relevant sections of Information Technologies Act says that if any company is handling sensitive personal data, they need to have these reasonable security practices, and non-compliance in that matter may result in a financial liability for which there is no upper limit. It can also result in criminal punishments of up to 3 years. And this reasonable security practices includes what is contractually agreed to between a company and its other person who supplies the data, and where such a thing is not available, a contract is not available or an agreement is not available, it is directed by the law which is in force, or in the absence of either an agreement or the law, it is dictated by the checklist perhaps which the government will work out. And today, of course, there are companies we may say that we do not know what is sensitive personal information, therefore we do not know what to do and what to protect. But we have various principles of information security in global privacy laws which make us realize what exactly is sensitive personal information, and we need to follow all these things in a manner in which the sensitive personal information as recognized by the information security practitioners world over need to be also looked into as the principles under which we have to build our information security practice. This requires not only securing the information in storage, but also information in transmission and information in the data backup level. And every, I guess, professional today therefore have to develop their standards for this particular reasonable security practices and understand provisions of Information Technology Act under various sections. It may not be necessary for me to go through the details of each of the sections, but I would like to quickly tell you certain sections which we need to follow or we need to take cognizance of. Section 43, which talks about liability for various contraventions. 72A, which talks about the criminal liability arising out of breach of a lawful contract. And then Information Technology Act talks about two other things which are directly related to corporate information security practice. One is authentication, in the sense that Information Technology Act recognizes only digital signatures as the means of authentication of an electronic document. It can recognize who has signed a document, it has recognized what has been signed, it can provide non-repudiation, and it can also provide confidentiality. And together digital signature represents a very important information security tool in an organization which provides for one-to-one messaging in a secured manner, very economical, very convenient. Unfortunately today in the corporate circle we use digital signature only to make MCA returns, but we don't use it for any other communications between the company and the external entity. The second aspect which Information Technology Act has made a substantial difference is in prescribing what is called e-auditing. And to understand what is e-auditing, we need to look at this section 7A, which says where in any law there is a provision for audit of documents, that provision shall also be applicable if the documents are maintained in electronic form. Therefore, if we as a company have any legacy laws of audit in paper form, when we start putting this paper form documents into certain electronic files, and in our computer we have hundreds and thousands of such auditable or audit required documents, we need to have a system of an appropriate e-audit. I personally, whenever it is required, use a particular tool for such audits, which actually provides me to list out all the documents in a particular folder with their name and with the hash value on a particular date, and have a signed statement saying that these documents were checked by me on such and such a day, and this was the hash document, and if necessary on a later day I can verify the particular files and say these documents were verified by me today, and compared to the last time I verified, the hash codes match or hash codes don't match, and in that list whatever documents are indicated as hash codes do not match, they are the documents which I pick up for manual auditing. This sort of e-audit tools today become absolutely essential for companies to do their day-to-day operations, particularly if they keep the documents in electronic form. In addition to this authentication and e-audit, one more new provision which has come in Information Technology Act 2008 is section 67C, which mandates data retention for a certain period of time. We need to understand what are the requirements and the company should provide that. Additionally, it provides that companies should be in a position to actually provide some information to the security authority called CERTIN, and if they are not in a position to give that information when called for, they will be liable for criminal liabilities. And for enabling this, it is necessary for the company to actually do something proactive today to ensure that the information which is likely to be demanded by the CERTIN is always available for uh, extracting from the company's records. In fact, according to the latest guidelines, every company has to designate a person as a compliance officer, give his contact details to CERTIN so that CERTIN may be able to call him at any point of time. Other than this, any of our employees contravening the law, as we have already told, creates a vicarious liability risk for the company, and this could fall on the organization as well as the executives. It is in this context that all of us need to actually sit back and ask, is my company protected against cyber crime risk and any liabilities arising therefrom? And HR particularly has to start their activities in building a information security awareness and making every employee an ethical employee. And the top management has to support all the activities which go towards providing the security environment, whether it is provision of financial support to the IT security or building an IT security culture for the organization. Therefore, the need of the hour for corporate executives is be aware of what is there in ITA 2008, comply and feel secure. This is corporate governance for the year 2010.